today's video, we discuss key mistakes medical spas are making in their legal compliance and how medical spas can thrive instead of floundering in a complicated legal maze. Hi, I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We've advised over 1,000 healthcare industry clients on healthcare and FDA legal issues, and as a result, they've successfully launched or grown their existing health and wellness product or service line. Just imagine how far down the curve your healthcare business or practice could be with a modicum of focused legal advice, especially at the outset, but all along the way. Now, Jane is a licensed registered nurse, and Mark is a licensed medical doctor. Nurse Jane is great at marketing. She brings in tons of patients. She found Dr. Mark. He had his own primary care private practice, and she convinced him that he could add to his income by doing some light supervision for her thriving medical spa. So Nurse Jane had a great virtual coffee, and Dr. Mark is in. Nurse Jane called us. She introduced Dr. Mark as her partner in the venture, and then she corrected herself and said medical director. Well, this is where the hook comes in and the buzzer sounds, because it might seem like a language game or a match made in heaven, but the idea of having a partner in a medical spa who's a fellow licensed healthcare professional is often a huge compliance no-no. Of course, there is a mix and match Moscone-Knox Professional Corporations Act. We'll talk about that elsewhere. While the term medical director is immensely popular, especially among healthcare startups, many prosecutors look at the term medical director as proof that the venture has violated corporate practice of medicine. Again, we have much more detail about this in a blog post entitled, "If Someone Asked You to Be Medical Director, Run." Now, let's take a step back and get the bird's eye view so we can get you a little bit more oriented here. You'll want to think about a medical spa as really being two ventures in one. I don't know if any of you remember that old commercial about Certs. You know, it's two mints in one. I never forget those commercials that I watched in childhood. So here's what you've got, right? Two ventures in one. So first you've got the medical venture, and second you've got the business venture. The medical venture is headed by the MD, who provides medical grade therapies to the patients, and these therapies, like Botox, require a medical license to prescribe. They require an MD or an appropriately supervised mid-level professional, such as an RN, to administer. Now, there's a carve-out for the advanced nurse practitioner. But for now, just to say that these things can't be prescribed or administered by a layperson. The medical venture might be in the form of a professional medical corporation, or in some states a PLLC, or professional limited liability corporation. In some states like California, now we come back to it, there are laws that allow licensed healthcare providers to mix and match. So you might have the MD as 51% majority shareholder and president of a professional medical corporation, and the RN is 49% minority shareholder and employee of the professional medical corporation. This brings its own complications. There are a lot of details to work out here in terms of revenue streams and who has control over the professional corporation and who owes what duties to whom, and when it gets unwound it can be a mess. But for now, we're talking about the separation of the MSO side with the business management and marketing services, and the clinical side, which provides the medical and the RN services. The compliance reason for the MSO is to separate out the business functions and comply with prohibitions against the corporate practice of medicine, or CPOM, or CPM, as well as fee splitting or PI kickback rule. The MSO should get paid at fair market value for providing management and marketing services to the medical corporation. And once we get the regulatory issues ironed out, typically our medical spa clients will need to have their core documents drafted or reviewed. For example, consent forms, an office policies form, privacy policy, terms of use, various agreements, employment agreements, contract agreements, vendor agreements, agreements with the mid-levels, and the shareholders agreement if you've got the mix and match scenario. Now, there are many corporate lawyers out there who like giving advice about documents, but some don't, and many understand that a healthcare lawyer is very specialized. It's a regulated industry with its own language, its own liability pitfalls that can besiege a healthcare practice or business. Because we focus solely on the healthcare industry, this is within our wheelhouse, and this is what we love doing. Thanks for watching. With questions, contact us, cohenhealthcarelaw.com/contact to send us a message or book an appointment. Here's to the success of your medical spa or other healthcare venture. We look forward to connecting with you soon.